Good afternoon. My name is Mark Kinghorn. I'm a lawyer here at McGuire Woods. We are so happy to be able to host all of you who are in the room. Thank you for coming and joining us here. And also so good to see so many who have joined by video. You guys are very welcome to, and we appreciate you participating in this as well. Todd wanted me to remind you that we can see your names on one of the big screens here, which means that if you turn your camera on, we can see you. So you might want to keep your cameras off unless you have a question or have something that you want to say. But welcome. We are really happy to host you for this session as part of the Charlotte Triage program. Let me just offer a couple of thank yous, and then I'll introduce our presenters, and we'll get going with the housing CLE. Again, my name is Mark Kinghorn. I'm one of the housing champions and have been for a number of years now. We have expanded our number of housing champions as the project has evolved. And let me just introduce, I know a number of them are in the room here, so let me just name all of our current housing champions. Paul Osowski from Nelson Mullins, Tim Hughes from Bank of America, Bill Butler from Moore Van Allen, Dana Lumsden from Bradley, Ella Marie Smith from Deckert, and Christopher Dixon from Cadwalader. So thank you to all of the housing champions. Let me also just thank Angie Zimmern and Todd Stillerman for all the incredible work that you guys do on the Triage project broadly and housing in particular. Todd especially has just really dug in and been a huge, not just supporter, but an on-the-ground helper of this project as well. So thank you to all of you for your leadership and your guidance through this project. Now let me introduce our presenters. Many of you may know one or both of these guys. They've been with Legal Aid for a little while now, and these are your absolute experts when it comes to housing and landlord-tenant matters in Mecklenburg County. They are brilliant. They know the rules. They know the magistrates. They know the process. And they are incredibly responsive if you have questions about anything. So I would encourage you to listen to what they have to say here today, but also don't hesitate to reach out to either one of them if you're involved in a housing matter and you have questions about anything. So on my right here is Isaac Sturgill. Isaac is the Housing Practice Group Manager for Legal Aid of North Carolina. And on my left is Justin Tucker, who's a senior attorney at Legal Aid of North Carolina. These guys are heavily involved in housing. It's what they do. Like I said, they are real experts in the field. And I would be remiss if I didn't also mention that Tommy Holderness is sitting in the audience here as well. Tommy is also an incredible resource and really helps to lead the program at Legal Aid as well. So I'm going to turn it over to them. We have about an hour and a half or so of a CLE, and then we will adjourn from here and go over to the Bohemian Hotel for a reception. And I hope all of you can join for that as well if you signed up. Thanks, everyone.
Thanks, Mark.
Thank you.
Hey, everybody. Thanks for having us here today. It's great to see the turnout for this event. It's really encouraging, and also to see some people that we see in the courtroom that are already volunteering for the housing work that we do. So again, my name is Isaac Sturgill. I manage the project, the Eviction Prevention Project in Charlotte for Legal Aid. We've got a staff of maybe 15 to 20 people doing eviction prevention work. In Charlotte, to give some context though, there's about 30,000 eviction cases that go through this county each year. So with our staff, we were able last year, for example, to close about 1,700 cases, which is a lot. And that's a lot of work, but it's only a small percentage of the total number of cases, which is why volunteers like y'all are so important. And we appreciate y'all so much. We're going to cover a few different things today. We're going to talk about the court process, the eviction court process, and we're also going to get into some substantive law as far as the different types of eviction claims and then some of the most common defenses that we use. But I wanted to start just by talking about the eviction process itself. Landlords do have to go through eviction court to evict the tenant in North Carolina. So one of the important things to remember is that's the only legal way to do it. Unfortunately, we do see illegal evictions happen sometimes, and those are what we call self-help evictions. Landlord can be pretty creative with that. I mean, it could be anything from changing the locks without a court order, cutting off the tenant's power, cutting off the tenant's water. We had one landlord that used to remove the doors on the property during the wintertime. So anything like that, anything outside of the court process is illegal. And in those situations where we do have Self-help evictions, we will file lawsuits against the landlords and seek an emergency injunction to require them to undo that harm. So there is a legal process we can go through if that happens. But the actual legal process, it moves really, really quickly. These laws favor the landlords. It's meant to be fast. And so the legal term for an eviction in North Carolina is a summary ejectment. And the process is lightning fast. So under the statute, once the case is filed, the trial is supposed to happen within 7 days' time. That's when the case is filed, not when service is achieved. So it's actually very, very common for our clients to call us having just been served with their court papers, and they may have court within 2 to 3 days. Sometimes it's the next day. So there's basically no time at all for the tenants to prepare, really. And it just moves very quickly, which is one of the things that's really, really challenging for tenants about it. Another thing that's unique about eviction cases is they can achieve service by something called posting. So they don't have to get personal service on the tenant. They don't have to have it put in their hand. Posting means that the sheriff just goes out to the property. They'll knock on the door. If an adult answers the door, they'll give it to them. But if nobody answers the door, they can achieve service just by taping a copy of it on the door and then putting a copy in the mail. So you can see how that could be problematic. We've had situations where a tenant may be gone for a couple of weeks to visit family and come back and they've been evicted and they never even knew about it because service was done by posting, the trial's already happened, and it's over at that point. A lot of times, because it happens so fast and because people have real lives and they have jobs that they have to go to and other obligations, most tenants don't show up for court. So that's part of how the process works in this stage. You might see a docket with 50 cases on it, and you might have 5 tenants that actually show up. And so that's another thing that's challenging. And when they don't show up, the landlord can get a judgment just by basically resting on the pleadings in that situation. The tenants that do appear, if they don't have an attorney, usually what they're doing is they're either trying to ask the magistrate who acts as the judge for more time, or they're trying to explain why they got behind on the rent, their circumstances. But it's very rare that they actually have been able to identify a legal defense that they're going to raise. They can ask for a continuance, but under the law as well, even if the magistrate agrees to grant a continuance, the longest the magistrate can do that far is 5 days, unless the landlord agrees. So, on the rare occasion that the magistrate allows it, it's really just going to push it off to the next week. And an answer is permitted here, but it's not required. So that's another thing that's kind of unique about small claims court is the only required pleading is the complaint that's filed. And so typically you will not see tenants file an answer unless they have counterclaims. And we're going to talk about some of those counterclaims here in a minute.
So there's one firm here in Mecklenburg County, and I'm not going to name any names, that files roughly about 2,000 summary ejectment cases a month. And most of the time it's within a 2-week window. Each day that firm has cases on the docket. A lot of times it's on one docket, that's 100 cases on it. But because they file so many so often, a lot of times it's also spread amongst 2 or 3 dockets. And most of the time their clients don't come to the court or don't come to the trial. And so if the tenant shows up for court, a lot of times that counsel will often try to prove its case by calling the tenant as a witness and then ask them questions as far as any kind of notices or any documents that they have received. If the tenant fails to admit the necessary facts, in the middle of the trial, counsel will then ask for a continuance. A lot of times the judge will grant that, even above the client's objections to that continuance. And as we all know, sometimes we will make that argument and a judge will not grant the continuance because we're in the middle of trial. Contested cases with both sides represented are unusual. Virtually no tenants have representation unless it's legal aid. Occasionally, there are cases on the docket for money owed, but you don't see those too often.
Yeah, it really is a churn and burn model. So these firms that do these eviction filings, they charge a flat fee. I think it's only a few $100s, but they're filing thousands of them, a month. So it's kind of this process, and because of the short time frame in which the trials occur and the fact that most tenants don't show up for court, they're able to do that because out of that 2,000 cases, they might only have to actually deal with like 100 tenants that actually show up for trial. So it literally is a turn and burn type of model. So this is how we try to interfere with that. So we have a clinic that we do at the courthouse, and this is something. It's my favorite part of the job. Some of the people here have done it before. I see Bill and Todd and some others have participated. We get the dockets in advance so we can see what's going to be on in any given day, and we're able to decide when we want to do the clinic. We have a very good relationship with the magistrates and with the Chief District Court Judge Elizabeth Trosh and with the clerk of court Lisa Chingary. And so we have a lot of flexibility about when we go. We can go basically whenever we want to. And what happens is the magistrate will actually announce at the beginning of the calendar call, legal aid is here today. If you're a tenant and you're looking for representation, raise your hand and you can step out into the hallway and speak with legal aid, and we'll hold your place on the docket so you don't get skipped over. And Tommy will tell you sometimes when we're even not doing the clinic, the magistrate will tell people that because we're there and because they feel bad for the tenants. And basically what happens then is we will screen them for eligibility. That's really fast. It takes a couple minutes, and we'll sit down with the ones that are eligible and we'll talk to them about their case and we'll try to help them identify any kind of legal defenses that they have. It could be that we just give them advice and that's all that we do. It could be that if we see a defense that we're ready to do that day, we might jump in and actually represent them at the trial. What happens some other times is that we'll notice that the tenant does have defenses, but they may not be very prepared. So if they're complaining about a lot of repair issues, for example, but they don't have pictures with them, if we go on the record for them, we can get the magistrates to give us a continuance so we can have time to help them get ready for that. And for the ones that don't qualify, we still have information that's helpful about the appeal process, which we're going to talk about a little bit later. And typically, when we do this clinic, we're there for maybe like 2 to 3 hours. And for the volunteers that sign up to do this, you're there with a subject matter expert. You're there with the legal aid attorney, myself or Justin or Tommy or somebody like that. So we're there with you, and the ask is only for that day. So the volunteers, when they come in, they're only expected to be there for that 2 or 3 hours and to help and give advice and help us with the clinic during that time. They don't have to hold on to a case if they don't want to, although sometimes the volunteer and the client get a rapport going and the volunteer wants to, like Todd did a clinic. It was during the pandemic because it was strange because everything got delayed because of a backlog. But Todd and I just wrapped up a case that's been going on for months, and that started as a clinic case. He won the case in small claims court. It went up on appeal, and then we were able to negotiate a good deal for the tenant on appeal. So, but again, for the volunteers that are coming out, we're just asking for you to be there for that day. You did a clinic recently. You gave some advice to somebody, and they won the case by themselves. Do you want to talk a little bit about that, or you want to wait until we get to the?
We'll go into the end. Yeah.
You want to okay. So.
Mention how the conflicts. They can get around conflict if they're only.
Oh yeah. So as far as conflict checks go, we do get the dockets in advance. So that's one thing if you want to do one. But we also found I forget which rule it is, but it's one of the rules of professional responsibility. There's an exception to conflict checks where if you're doing this type of clinic work at an event like this, you can proceed without doing a conflict check as long as you don't have actual knowledge that there's a conflict. So there's actually a rule of professional responsibility that protects against that, which I never knew. We were just digging through the rules and found that recently. But that's interesting too, that in these type of clinic models, as long as you don't have actual knowledge of a conflict, the bar says you're free to proceed on that.
Isaac, will you send us that site so we can share?
Yeah, Tommy, do you remember the rule? 6.5. There you go. Thank you.
So regular intake at legal aid. So we get about 120 cases per month, which averages out to about 30 per week, which is why it's super important that we have you guys as pro bono champions and to help us out and volunteers, because we just don't have enough manpower to get through everybody. We kind of focus on small claims in the appeal window, cases that are waiting district court, cases where there's a writ pending execution or pending a writ being filed. notice to vacate cases, whether subsidy or non-subsidy, repair concerns, as well as subsidy issues where there's a problem with getting a subsidy or maintaining that subsidy.
We're going to talk about that a little more in this presentation. We're going to go through the appeal process itself in detail and the repair issues and those other types of defenses in just a little while. At the actual trial, so a small claims trial, what it looks like, you go in the courtroom, the civil magistrate acts as the judge. Magistrates in North Carolina do not have to be attorneys. I think all of ours are, and they're actually pretty good about respecting the rules of evidence and civil procedure. There's a statute in Chapter 7A that says the rules of evidence and civil procedure generally apply in small claims matters. We don't know what that means. They seem to respect them. And some counties it's not like that. There's some of the rural counties, you walk into the court and it's not even a courtroom, it's like the magistrate's office, and you walk into like, what's going on here, you know? But it does feel like court. You know, there's two tables for each side. Opening statements are not typically done. You can ask to do one. The magistrate might look at you strange if no one ever does it. I don't know why, but opening statements don't really happen. And so usually they just go right into the plaintiff's case. So they'll call the case up. Are you ready for trial? Yes. They'll say, all right, plaintiff, you know, go ahead and present your case. Trials they're not recorded. So there's no like record that's being made. So in state district court or all across the state, they have an audio recording of all the trials. There's nothing like that for small claims court. And so if you think that the landlord may say something incriminating during the trial, you might want to bring a paralegal or a friend or somebody that can sit in the courtroom and take notes, and maybe they could be a witness in the future, but just realize there's no recording that's going on. The magistrates have very little courtroom assistance. A lot of times there might be one deputy that's kind of like walking throughout the various courtrooms. So there's 4 courtrooms that do eviction trials every single day of the 5 days a week. So that one deputy might be just circling through them. But the magistrates don't have much assistance. A lot of the parties are pro se. You know, there's not a ton of attorneys in there. And so they really do appreciate well-organized presentations, you know, having enough copies for everybody, having things highlighted, things of that sort, because they have very little help. And they typically rule immediately at the end of the trial. So the way the rules work is that if the magistrate announces the judgment in open court, the court will not send a copy of it to the tenant. So the tenant, to get a copy of the judgment, will have to, you know, wait a couple of days and then go to the clerk's office and try to pull the file for that. But the magistrate does have the authority to reserve judgment, but then again, because everything's on a fast timeline, they have to issue their decision within 5 business days.
All right, so this is what a complainant's summary judgment looks like in North Carolina. And as self-explanatory as it is, landlords tend to screw this up a lot. So a lot of times where you're going to see it, again, it's self-explanatory, but a lot of times you'll see mistakes where description of the premises, the landlord doesn't put a proper description on the premises. Generally, it's going to be the client's address, apartment number, and everything. The rate of rent is the tenant's share of the rent, whether it's subsidized or not, their portion of the rent, and the bare bones rent. It doesn't include the trash fees, the pest control fees, just the bare bones rent that the tenant is responsible for. Date rent due, generally, the landlords or landlord attorneys, they will put the breach date in that box, meaning the date that the tenant failed to pay rent or the date that the breach occurred. And the date lease ended.
With the type of lease, so, you know, leases in that can be oral or written, and we're going to talk about that a little more when we jump into these claims. Leases don't have to be in writing unless it's a lease for longer than 3 years, which we never see that. So oral leases, we do see that sometimes, like a verbal lease. These 4 boxes, so if you look in paragraph 3 up here, those 4 boxes represent the 4 different types of eviction claims in North Carolina. There's only 4 of them, so they have to pick at least one of those. Sometimes they won't pick anyone, which is a problem, or sometimes they'll just check all four just to cover themselves, I guess. I don't know. But we're going to walk through each of those in a little bit of detail to kind of explain what those four different claims are, what the elements of them are, and then what kind of defenses can apply. The first one is a statutory claim for non-payment of rent. We're going to talk about when that's used. The second one is something called holdover, and that just means that the term of the lease is over and the tenant has not left. The third one is the most common by far, and it's for breach of lease. So they broke some rule in the lease, and the lease gives the landlord the option to terminate upon the breach. That can include non-payment. And so you might ask, well, why are there two different claims where they can bring a claim for non-payment? We're going to explain that in just a minute. And then the fourth one is rare, but I think these trials are really fun, which is a criminal activity. So there's a law that allows landlords to evict tenants for certain types of criminal activity. And there's a whole it's Article 7 of Chapter 42 that walks through that. So those are rare. Those are maybe like 1% of the cases that we see. But I think they're a lot of fun. They're usually super interesting. And you get to kind of pretend to be a public defender because you're trying to prove they didn't commit whatever crime they've been accused of.
Hey, talk about why the rate of rent is so important for appeal. Make sure they get it right.
Yeah, the rate of rent. So if the tenant loses, the tenant can appeal. And we're going to walk through this in just a minute in more detail. But to stay in the home on appeal, the tenant has to start paying their rent into the court as a bond. And so they call that a rent bond payment. So the rate of rent is really important, especially for tenants that are subsidized. So like a Section 8 tenant, for example, the rent may be $1,000 a month, but their portion of it may only be $200, and then the housing authority pays the rest of it, right? So if that's wrong, like let's say they set it at the $1,000 instead of the $200. That's really going to, screw with that tenant, because if they file the appeal, they're not going to be able to post the bond because the bond is the wrong amount. And then they're going to be evicted even while they're waiting on their appeal day. So that's why that's pretty crucial to make sure that that's right. For subsidized tenants in that situation, it's good to go to court even just to make sure that the bond's not messed up, right? Even if they don't achieve anything else, just getting in there and explaining to the judge, like, I'm on Section 8, my portion's only $180. We'll do something.
Just a quick question on that. So what do you do if it's wrong?
Yeah, that's a good question. So if you can catch it before the judgment's entered, you just explain it to the judge and they'll do it. Sometimes the clients come to us after this has already happened and the rate is wrong. There's a statute that allows you to file a motion to modify the rent bond. And there's a procedure for that. So you can file the motion. The court is supposed to schedule the motion for hearing within 10 days. So the hearing happens really quickly. But that's how you fix it on the back end if the judgment's already been set. And what the law also says, if you file a motion to modify the bond, the landlord's not allowed to execute on the judgment until that motion's been heard. So even if they haven't paid, if they're waiting on that bond modification motion to be heard, the landlord's not able to evict them in the meantime.
Is that a basis for dismissal? No. Can you get it thrown out on the basis of the rate is wrong?
Well, in some situations, maybe. I mean, there's situations where, for example, if the landlord lists the wrong rate of rent and is trying to collect, like, from a tenant, that might give you, we're going to talk about this some more moving forward, but that might give you like a debt collection claim or something because they're misrepresenting to the court how much the tenant owes them. And that might be a defense for non-payment. And we're going to get into the debt collection stuff here in a minute. So sometimes it can give you the basis for a counterclaim.
Or maybe it was a box one claim and they were asking for the full rent as opposed to asking for what was actually owed.
Yeah, we're about to talk about that.
And then another thing says that if you're catching it before the trial, I ask, what documentation, because the managers don't believe anything out of people's mouth. They want to see it in writing. So like if they're subsidized, say you have the paper from a Olympian showing what your rate of rent is. So not just they're saying it, but you go to the court and hang on a piece of paper saying the rent's $180. But if they don't have that, you have like the receipt from the last several months, anything in writing to show what it really should be.
Yeah, and Livian's our local housing authority. It used to be called the Charlotte Housing Authority. They went through this big like rebranding campaign for some reason, but now it's in Livian. In all capital letters. They're very particular about that.
Very particular about that.
Yeah. So we're going to jump right in, and Justin's going to start us off by talking about the first claim, and this is the statutory claim for non-payment of rent.
Right. So this is used only if the lease doesn't have a forfeiture provision for termination upon non-payment of rent. So what North Carolina has done is put this in place so that there is a forfeiture provision. And so what it requires is that first, that the tenant is late on the rent, the landlord must make a clear demand for the rent. And the landlord must wait 10 days for the tenant to pay the amount owed before filing the complaint for summary ejectment. And a lot of times you'll see where the notice doesn't give a full 10 days, or the landlord will file before the 10 days are up. Or
sometimes the landlord will list the wrong amount that's owed sometimes.
Yeah, they'll list late fees and other fees that are owed along with the rent. Sometimes they won't even demand the rent. They just demand you vacate. Or to be vice versa. They demand you rent, but don't give you the option to pay or vacate. And so the court, North Carolina gives the tenant an option to pay all the past due rent, including the court costs, up until a judgment is entered. So what that means is the tenant could actually come to court the day of trial and have all the money and say, Your Honor, I have all the money to pay the landlord the past due balance. If the landlord doesn't refuse to accept it, we've seen times where the judge would dismiss the case because they have that right and an option to pay up until the judgment is entered. Now, once that judgment has been entered, then you got to go through the appeal process and try to work on it on the back end.
And that's actually really fun to do because you know you're going to win because the magistrates all understand this. And you can be dramatic about it, but we do it in court in front of the judge. And then that way, the landlord can't say that it didn't happen. We're like, Your Honor, we're making a motion to tender rent under 42-33. Here's the amount that's owed. Here's the money. And go up and, offer it to the landlord in front of the judge. And that is hilarious because the landlord is like, I don't know, should I take it? The judge's like, I can't give you legal advice. It gets really awkward. But whether they take it or not, the judge will still dismiss the case because the tenant has offered it. So it's in their best. I think one time a magistrate did tell a landlord, I'm going to dismiss it either way, so you might as well take it. So we had a case like that where the landlord got super confused. It was really funny.
You can tender in district court too.
You can, yeah.
So as long as you appeal, you can tender before that judge.
Yeah, so if you appeal, and then you can tender on appeal as well.
Got a quick question.
Yeah. Oh, sorry. Yes.
Okay. Between the filing and the action period.
It's not long at all. It's within a week usually is when that happens. So
in theory, you're a tenant 10 days after the late.
well, but so they have to demand the rent, and then they have to wait 10 days before they file the case, and then after they file, any point up until the trial, the tenant can pay the money in court costs, and the case should be dismissed at that point. Another thing that's required is you want to talk about the surrender of possession? A demand for surrender of possession. So this is under 42-26. In addition to demanding the rent that's owed, the landlord also has to make a demand that the tenant vacate or give possession back to the landlord. It's actually baked into the complaint. It's one of the allegations in the form complaint that says that landlord's made a demand that the tenant surrender the property and the tenants refused. Funny story, we didn't catch on to this for years. So I've been doing this for 10 years. There's a landlord's attorney one day that does commercial work, and he was speaking with one of our attorneys, and he was like, yeah, I'm worried about this case coming up because my client didn't make a demand for possession. And we're like, what are you talking about? We've never heard that. It's buried in the statute. It's a few words in there. So we looked at it, and so we went on a campaign in Charlotte to start pushing this defense, and it has won hundreds, if not thousands, of cases for us over the last few years. When did we start doing that? Maybe 5 years ago or something like that. But for decades, we were just sitting on this and didn't realize that this was a thing. And it took a while to convince the judges that it was a thing, but they're all convinced now. We found some case from 1800 that backs it up, doing some research. We looked at the jury instructions on these types of claims in the jury instructions. It was this treasure trove of stuff that we never saw before. And now it's very much accepted. So pretty much literally all of the magistrates in Mecklenburg County recognize that defense. The district court judges do as well. And we've also pushed this around the state. So our offices all across the state have started using this, and we've just won a ton of cases. It's really interesting that we slept on it for so long. Uh-huh.
So if you have a case where all the other requirements are made, but there's no demand for surrender of possession, the judge has to dismiss the case.
Yep. And the policy there is that the policy is that the tenant should have an opportunity to leave before the landlord files the case against them, right? So it's giving the tenant a chance to get out before the litigation happens, which is important because it spends time and money, but also because it creates an eviction record for the tenant that's never going to go away, which is bad too. So that's the policy behind it. But yes, absolutely. If that's all the landlord did wrong, we can still get it dismissed based off of that. And I can't tell you how many times that's been the only thing that we've got. Like we don't have anything else besides that. For holdover, well, let me just stop there. Any other questions on that first claim? Just to point out on that too, this claim for non-payment, like Justin said, it's used when the lease does not have a default or forfeiture provision. So the lease can have whatever rules you want in it, but if there's not a provision that says if one of those rules is violated, the landlord can terminate the lease. The landlord cannot proceed on a breach of lease claim for eviction. So where do we see this? Verbal leases, because no one makes a verbal lease and they agree on that, and even if they did, there's no evidence of it because there's nothing in writing. Or really badly written leases. So sometimes we'll have like a mom and pop lease, or the landlord will print off a lease off of like LegalZoom from like a different state or something like that. So it's pretty rare. I mean, I think this is kind of a small portion of the non-payment cases that we see.
For the demand for payment, rent, and for possession, it's a practical matter. Do the landlords need to furnish evidence and that the demand is made?
That's a good question. So it does not, neither one of them, it has to be in writing, but if the tenant disagrees and says they never did that, the landlord's going to have a problem credibility wise just because they don't have any evidence of it other than their testimony. So it doesn't have to be, but it most commonly is because landlords, want proof of it.
And kind of as a follow to that, is it problematic for landlords who have attorneys, but they don't have an agent appear, so they don't necessarily have anybody there who can present?
Yeah, because most of the time, like we said, landlords don't show up with a witness. That's part of what they're paying their attorney for, is not to have to go to court, right? So the landlord will show up and they need to get that demand for possession, the proof of that, into evidence. What they'll typically do is call on the tenant. They'll call the tenant, like Justin was talking about earlier, to testify against themselves. And they'll hand them the notice and they'll say, didn't you receive a copy of this? And the tenant, if they did, and they say yes, then that's sufficient. And then the attorney can hand it up and make their case. Like Justin also said, if the tenant says no, then the landlord's trying to say, I need to continue. It's all signed, right? So that happens too. And unfortunately, a lot of times they get one.
So I don't know if this has been brought back at all, but in terms of the ability to pay when you're in court, are any of those agencies back that provide rental support, or are they all gone?
That's a good point. So during the height of the pandemic, y'all might remember there was an eviction moratorium for a while that was issued by the Centers for Disease Control. It's a federal moratorium. There was also a ton of federal money that went into rental assistance. There's a local organization called DreamKey that was providing massive amounts of rental assistance over the last few years. And we're talking like some tenants that had been out of work for a long time. They were paying for some tenants up to around $10,000 in relief and stuff like that. Millions of dollars went through that program. That program, all the money is gone. So we don't have like the large scale rental relief anymore. We do have organizations that have been around for a really long time. Probably the most widely known one is Crisis Assistance Ministry on Spratt Street. They're still around, but the amount of assistance that they can provide is much less than that. Like they might cap out at like $1,000 or sometimes $500, depending on how much demand there is. There's also an interesting question though of whether that counts as tender, right? So because Crisis will give a voucher that says, redeem this and we'll pay the money. Is that sufficient for purposes of tender? We argue yes. I've had a trial on that once, and the judge agreed it was tender, but landlords will try to argue that's not the same thing. That rental assistance isn't the same as like cash or a money order or something like that. Yeah.
Talk for a minute about the timing of the demand for possession and how much in advance of filing a complaint.
Yeah, so the statute is not clear on the demand for possession about how far in advance to filing the complaint it needs to be made. So what we argue, is that it has to be made after the breach occurs. And long enough before the trial date to actually give, or the filing to actually give the tenant time to get out. So we've had a situation where, like, for example, the landlord made a demand for possession in the morning, and then in the afternoon, they filed the case. And we're like, that defeats the entire policy of it because it doesn't give the tenant a realistic opportunity to get out of the property. How long is long enough? I don't know. Maybe a day's not, is 2 days, 3 days, I don't know. There's no statute or case law on that, but we do see that situation too, where it's made so close to the filing that we can argue it shouldn't be valid because it doesn't give the tenant an opportunity to leave.
Other one.
Whoops, wrong way.
One more.
So holdover, Justin, you want to talk about holdover?
Yeah, I can.
If I can stop messing with the remote, I'm just going to put it down. How about that?
All right, so holdover occurs when, occurs when the tenant stays after their lease is ended. Whether it ended because the lease ended on a certain date and it rolled over to month, or the landlord terminated the lease at a certain date and the tenant is staying after the fact. If the lease is now month to month or any other period, there must be sufficient notice giving the tenant to vacate, terminating the lease, and it must be at the end of the period, i.e. the last day of the month or the last day of that, the last day of the month. So some leases run from the 1st to the 3rd. It kind of depends on when the rent is due. So if the rent is due on the 1st or the 8th after the 5th, then the end of the period for that type of lease or that type of period would be at the end of the month. General Statute 4214 has the minimum notice requirements that the landlord also must satisfy in regards to the time of delivery requirements. Occasionally, the landlord fails to testify about all the required methods of delivery, and in some instances, we'll pop up on that. The claim fails if the landlord accepts rent after the end of the lease or signs a new lease. And just like Isaac was mentioning before, in a holdover situation, the demand for possession must be made after the lease has been terminated and before the eviction has been filed.
Yeah, and so what I think, in my opinion, and I think Justin will probably agree, the place where landlords screw this up the most is the first one. When Justin was talking about the notice has to end the lease at the end of the period. And we're talking about like a month-to-month lease, some type of periodic tenancy that doesn't have a definite start date and a definite end date, which is most typically a month-to-month. Typically the notice is going to have to end it at the end of a month. So the minimum amounts of notice are not a lot. So for a month-to-month lease, it's only 7 days is the amount of notice they have to give, but it still has to end the lease at the end of a month. So what happens a lot of times is landlords will give enough days, but they try to end the lease in the middle of the month instead of at the end. So the most common lease that we see requires more than the statutory minimum. It requires 30 days notice to end the month-to-month. And so, for example, you'll see the landlord do something like they'll give the notice on January 15th and say you have the lease is ending on February 16th or something like that, right? So they gave enough time, but because they didn't end it at the end of the month, we can get them on that. And that's probably the most common mistake that landlords make. And we make that argument a lot, and all four of the magistrates will recognize that.
And also, delivery of the notice must be in accordance with the lease. A lot of times the leases say the notice must be mailed or must be posted or must be mailed and posted. And so depending on what the lease says, we have popped the landlords on that because they didn't follow the lease in accordance with delivering of the notice and the timing of the notice.
Yeah, and we've got really good case law on that in North Carolina too. There's a lot of case law that says if the lease requires the notice to be given in some certain way, that the landlord has to strictly comply with what the lease says they have to do. I'll give you kind of a funny example. There's a lease from the National Apartment Association, and for whatever reason, and part of it says all notices must be signed. And so we've won cases off of the landlord not signing the notice because the lease says they have to do that, and the case law says strict compliance is what the standard is. So when we're doing these cases, obviously we're very closely scrutinizing the lease, reading the exact language, and looking at the notice and seeing if they line up or not. Violation of the lease term, this is breach of lease, this is the third box on the complaint, is by far the most common. This is probably 99% of the cases that we see, because most landlords are using form leases from the apartment association or something like that, and those form leases are all going to have a default provision in it. And so this is really really, really common. And again, the lease has to have the forfeiture provision. They have to describe what the breach is on the complaint to give the tenant notice of what they're saying the breach is. Usually it's non-payment, sometimes it's something weird, some other rule, like a noise violation or something like that. But they have to describe what it is. And again, like with holdover, if the lease requires a certain type of notice, they have to provide that. Now, as a general matter, under North Carolina law, landlords are not required to give someone a notice that they're going to terminate their lease on a breach of lease case. A lot of people don't realize that, but there's not a requirement under state law for a lease termination notice to happen. Now, the landlord still has to make the demand for possession, which is different. That's demanding that they get out, but they don't have to give them a notice of termination, of the lease termination. Some leases require that anyway, but it's not a requirement under state law. For federally subsidized tenants like Section 8, there are notice requirements under federal law, but as a matter of state law, there's not.
And a criminal activity.
And then, yeah, criminal activity. This is the fun one. So we're not going to spend a ton of time on this because it's pretty rare. But one of the things we looked at here is the crime something you can be evicted for, right? So the definition of the type of criminal activity that you can evict a tenant for under this statute is limited to certain types of crimes. It's limited to basically violent or drug-related crimes or crimes that disrupt the peace, basically. So there can be certain crimes that don't count. There's also an interesting exception where possession of a illegal drug for your own personal use is not considered an evictable crime. For whatever reason, that's what the legislature decided. So like if you get caught with drugs and you get caught selling them or manufacturing them or distributing them, you can be evicted for that. But if you get caught with drugs and it's just a small amount that you're keeping for yourself, they can't evict you for that under this statute. Now that could be a breach of lease depending on what the lease says, and maybe they can proceed under a breach of lease claim, but not under this. I had this really funny case one time against the housing authority where I had a young client, I think he was like 19 or something, that was caught with some like marijuana on him on the playground in the apartment complex. And they put on their whole case. They had like 2 police officers there. They had both the cops testify. They did all the, I didn't barely ask anything other than just confirming that it was like a small amount that was on him. And then I made a motion to dismiss based on the fact, yeah, they proved that he had drugs for his own personal use, but under the statute, that's not something that you can be evicted for. That doesn't count. And the house authority was so confused, but they're like, but he had drugs. And the judge is like, I know, but that's not how it works, right? So that one's funny. Some other things maybe that, like tax fraud, right? That's illegal. That's a crime. But it's not something that disrupts the community, or it's not violent. It's not drug related. So that's another example. There's certain types of crimes where it doesn't count. I think we had a case one time where someone was arrested it was a prostitution charge. And I think we tried that argument that wasn't that type of crime that was violent or disrupted the community. I don't remember how that case came out. But you can be thinking about like certain types of crimes might be illegal, but they might not be the type of crime that this statute's designed to evict people for. Couple other interesting things about this statute. There's different remedies available to the judge here. So the judge, if they grant the eviction, they can evict the entire family if they decide to do that. But they can also do a couple of other things. They can do something called a partial eviction. So if only one member of the household is the one that caused the trouble and the other members of the household are innocent and they didn't know anything about it or they tried to stop it, the judge can evict the person that committed the crime but allow the rest of the family to stay. That's one example. Or if the crime was committed by a guest of the tenant, so they're not on the lease, but it's somebody visiting them, and the tenant can prove that they didn't know that the crime was going to occur or that they tried to stop it, instead of evicting the family, the judge can enter something called a conditional eviction, which is basically an order that says the family gets to stay, but if they allow this person back onto the property, then it's like automatic judgment in that situation. Where we see that the most, we'll have like a lot of situations where maybe the client is like an elderly, like grandma, maybe like the matriarch of the family, and she's got like 3 grandkids living with her, and maybe the oldest one gets into trouble, but the other ones are still in school and they're not doing anything bad. And we'll try to argue that to the judge, get rid of the one that's causing the trouble, but these other people didn't do anything, leave them alone. And we're pretty successful with that when we get a chance to do that. The last thing I'll say about this before moving on, this is the one type of eviction case where you do have to file an answer. So before, when we were talking about in most eviction cases, you don't have to file one. You do in these, or you can be defaulted on. You don't have to file it before small claims court. But if the case goes up on appeal, you have to file it within 20 days of when the appeal is filed. And again, if you don't, they can get an entry of default and you lose. Yeah, there's more we could talk about with that if we have time at the end, maybe, but we'll move on because this is pretty rare.
So some of the common defenses you may argue will be retaliatory eviction, which typically that's when the tenant or the resident has complained to the landlord regarding repair issues or some other issue going on, and then the landlord turns around and evicts them because of that issue. It could be considered retaliatory. Now, North Carolina has carved out some exceptions to that, which kind of makes it hard for us to argue retaliatory eviction. One of the exceptions is that the landlord can evict if you haven't paid rent. And so it's kind of hard to argue retaliatory eviction when there's a non-payment of rent issue at the same time. Same thing when there's a holdover issue at the same time. It gets a little harder to argue it, but you can still be successful, depending on the timing of when the complaints were made, when the landlord was notified, and then when the landlord took action to file an eviction. Victims of domestic violence.
Well, with the retaliatory eviction thing, so the retaliation aspect of it is like the landlord filing an eviction complaint in response to the tenant taking some kind of protected act. And like most typically that's the tenant complaining about repairs, but it can be any right that the tenant has under state or federal law. So the tenant asserts takes a protected act, and the landlord files an eviction within 12 months of that period, then that's when you can try to use the defense.
And victims of domestic violence have certain rights in order to get out of the lease, to get away from the abuse or the domestic violence that they're facing, as far as terminating the lease early, having the locks changed, stuff like that. So we've used that a couple of different times. Waiver is a very common defense that we see a lot. The only time where I've seen where it wouldn't work is where the lease has an anti-waiver provision, where the landlord can accept the rent after the alleged breach, and they still don't waive their right to terminate for that breach.
Yeah, and another important thing with that, so waiver, again, is where the landlord accepts rent after the breach occurs, so they've waived their right to enforce the breach. The landlord also has to know about it, though, so they have to have knowledge that the breach occurred, but if they accept rent after that, they can waive it. Do you want to talk about the anti-waiver clauses? Like a lot of times there'll be one in the lease, but it's not good, right? Or it doesn't do what the landlord wants it to do.
Yeah, you could.
Yeah, so another thing too, if you're doing a case and you see an anti-waiver clause, you really have to read it because there's a ton of them that don't actually work. They'll say really funny stuff like if the tenant commits a breach and the landlord doesn't evict, that the landlord doesn't waive the right to evict them for the same breach in the future. It's like, okay, but that's not what this defense means. We're talking about accepting money after you know a breach has occurred. So if you get a case that has an anti-waiver provision, you've got to really scrutinize it because a lot of times it won't be effective. It has to say something along the lines of the landlord can accept rent after a breach and still proceed with the eviction.
Another common defense that we talked about earlier is invalid notice. Sorry.
Repeat this, one of your on-site viewers wants questions repeated.
Oh, okay, gotcha.
Does that include partial rent?
So the question is if that includes partial rent. As a general rule, we argue yes, but there are some leases that have a provision that says that acceptance of partial rent does not constitute waiver. But as a general rule, we'll argue that acceptance of any rent after the breach counts as a waiver, unless the lease says otherwise.
Yeah, okay. Other defense, invalid notice, goes back to demand for possession as well as any lease terminations or the 10-day notice to pay or vacate. Again, several different ways that could be messed up. It doesn't give you 10 days, doesn't ask you to pay, only asks you to vacate. The notice doesn't demand possession, just is a past due notice. The lease termination notice doesn't terminate the lease at the end of the term, so on and so forth. Another common defense is the failure to offer reasonable accommodations. And I'll let Isaac talk about that a little bit more.
Yeah, so that's under the Fair Housing Act, which says that if a landlord's not allowed to discriminate against a tenant on the basis of the tenant's disability, and within that discrimination includes failing to accommodate a tenant's disability as long as it's reasonable, as long as it doesn't it's not overly, onerous on the landlord. So some of you might be familiar. There's a similar concept in employment law, right? It applies to housing too. Where we see that come in sometimes, I'll give you an example. I had a client whose son had some mental health issues like schizoaffective disorder, oppositional defiant disorder. He changed his meds. He was off his meds. He had some incident where he threw a brick through the window of the leasing office while he was having kind of this like manic or delusional episode. And then the landlord filed an eviction case against the family based on that. They had it on tape and everything. They knew who it was. So we looked into it. We found out that that episode or that outburst was related to his mental health issues and the fact that his medication had changed and it was affecting him in a certain way. And we got a doctor to sign off on that. And we got a doctor's note that said exactly that that was symptomatic of his mental illness and that the meds had just changed, and et cetera. So we made a request after the eviction was filed, but we made a request to the landlord and we said, hey, we're making a reasonable accommodation request that you give this family another opportunity, that you dismiss the eviction case. She'll pay for the window, they'll pay for the window, but you should not proceed with the eviction based on this because it was symptomatic of this mental health issue. And the way we made it reasonable was by getting the doctor's note to include some language that, his medication has now stabilized, like he hasn't had any similar episodes for the last 3 months, to show that it's not going to happen again, right? That this was like a kind of a fluke or the result of that medication change. And the landlord in that case, they hired Chris Losak is like the most prominent landlord attorney in the state to represent them, and they ended up dismissing and they granted the accommodation. The Fair Housing Act is very scary to landlords. There's a lot of liability under that. The biggest, settlement I ever got was from a sexual harassment case under the Fair Housing Act, and you can look up online. There's multi-million-dollar settlements and stuff in some of these cases. So it's a very powerful tool when you can use it. It's very rare for a landlord to deny one of those requests because it's just the Housing Act is very scary for landlords. Yeah.
The FHA is not limited to subsidized leases. Is that right? It's any.
It goes across the board. There's certain requirements. And another thing, there's a federal Fair Housing Act and there's a state version, and they're mostly the same, but they're a little bit different. There are some exemptions, like there's an exemption called the Miss Murphy exemption. I like that one because my cat's named Murphy, but I don't like the exemption though. But it's basically like if the landlord's living in the home and it's less than, they're renting to 3 families or less, and they're also living in the building, then they're allowed to be as racist or whatever they want to, I guess. They're exempt from the Fair Housing Act. And that's for some things under the Housing Act, not everything, but there are like weird carve outs and stuff like that.
Explain the distinction between defensive versus burden of proof and how, even the magistrates use those terms interchangeably when there's really a difference.
Yeah, so Tommy was saying, explain the difference between defenses and then the landlord's burden of proof. So things like retaliatory eviction, fair housing violation, waiver, those are affirmative defenses where you have the burden as the defendant to put on evidence of that and establish that defense applies in the case. That is different from the landlord meeting their burden of proof for whatever claim that they filed. So back to demand for possession, the demand that the tenant has to leave, which applies to everything except for criminal activity. That's an element of the landlord's claim. And so if the landlord puts on their case, but they don't put on any evidence that they made that demand, then we can make a motion to dismiss as soon as they rest their case, and the judge will rule on that. For the people online, y'all have to enter in a code or something to get credit. So the first code is Triage. So just to let you know that if you need to put that in for your CLE credit, it's Triage. That's the first one. So we'll see a lot of that too, where, and if the landlord forgets to put on an element of their claim, we just stay quiet. We're not going to like cross-examine them and be like, you never made a demand for possession, did you? Because then they're gonna be like, oh yeah, thanks for reminding me. Yeah, I did, right? So if it's that type of case, they have to go first. So if they forget to put one of their elements on to get proof of it, we'll just sit quiet, and as soon as they're done, we'll make sure that they rested their case, and then we'll stand up and we'll make a motion to dismiss.
One of the most basic things there is they have to introduce the lease into evidence, the document into evidence, and you'd be amazed at how many landlords, some of them even represented by counsel, they'll put on their case and they'll just either fail or forget to just put the lease into evidence. Once they have rested, if they haven't put the lease into evidence, you can almost always move for judgment at that point.
Yeah, one of the most important questions you can ask is the landlord, are you done? I mean, seriously, before you start talking, because you want them to say, yes, I'm done. It ain't hard.
Yeah. So,
I've actually watched Tommy ask the landlord that like 5 times.
yeah.
There you go.
So,
You're done?
for the people online, so Mark was talking about the fact that, one of the most basic things the landlord has to do to meet their burden is to put the lease into evidence. And Tommy was just saying, yeah, we stay quiet if they forget to do something, but you have to make sure you ask them if they're done before you make your motion to dismiss, because you can't make the motion to dismiss until they've rested their case. So if you try to do it before they're actually done, you're just going to clue them in, and if they still have an opportunity to present evidence, they can still do that.
Yeah, and ask if they're done with their case, not just done with their witness.
Yeah, ask if they're done with their case, not just the
Because
witness.
they could just be done, with their landlord, but then say, oh, it's gonna call your client.
Yeah.
So in that instance, if you get the dismissal, are they able to just refile again immediately, or is there like a buffer period where they can't refile again until another month goes by or something?
That's a good question. So the question is, if we're able to get a case dismissed for one of these reasons, can the landlord turn right back around and file another case? They can eventually file another case, but there's going to have to be some new grounds for it, right? So let's say the tenant doesn't pay rent for February, they try to evict for February, they fail. If the next month the tenant doesn't pay rent again, then they can file a new case based off of March's rent not being paid, but they can't refile a case for the same thing, because that's where, res judicata comes into play. We will see that landlords, that instead of filing an appeal, sometimes a lot of the pro se ones they'll get mad and they'll go right downstairs and file another case, and we'll come in, we'll show a copy of the last judgment, and we'll argue this is barred by res judicata, and the judge will throw it out. Yeah.
And is February never has to be paid, or would it have to be paid in March?
So they can't evict for non-payment of February's rent. So the tenant still owes it, but it's let me rephrase that. Landlords have an option only to sue for possession, or they can sue for possession and money that's owed. Most of them only proceed on just the possession claim, and they preserve the money owed claim. So if the case for February's rent got dismissed, but they were only seeking possession, they could foreseeably file like a money owed action for February's rent, but they couldn't file another eviction action for it. If they file a money owed action, then they might get a money judgment against the tenant, but they could not get an eviction judgment for February's rent at that point, which this is advice that we give our clients sometimes. If our clients get behind, they're a month behind, let's say that example, they didn't pay for February, the landlord takes them to court for eviction, the landlord loses. We'll advise the client, if the client can't catch up all the rent, we'll give them advice and say, next time when you pay your rent for March, do it on a money order and write on the memo line March 2023 rent, so that the landlord can't accept it and then claim that they're applying it towards February and then evict you for not paying March. And that works. It's annoying for the tenant because they have to write down, they have to be really careful about writing down what it's for every month, but that works.
There's a question about why they don't do it. You got to get personal service to sue for money, so you can't get a money judgment if you just served them, unless they show up. If you just served by mail and posting.
Yeah, so Tom is saying,
because LoSAC does the cheap, they don't do much because they're doing it so cheaply. So they'll just do possession cases.
yeah, so Tommy was expounding on why sometimes landlords will only seek possession, or they only get a judgment for possession and not for the money too. And it's because they need personal service to get a money judgment against the tenant, unless the tenant shows up for court. But if they're not, otherwise they have to have personal service. Did you have a question?
You may have answered it, but I just wanted to clarify. So you're saying in a situation where you get the dismissal for February, the landlord comes back in March to file for an eviction for failure of rent. The tenant then gets the money order, pays rent, puts March 2023 on it. February is forgotten about at this point because of the dismissal.
Well, so going back to our example, the question is if the tenant does what I'm saying, and let's say they didn't pay February, landlord files an eviction case for February, loses that, the tenant the next month pays March's rent, but puts on a money order. This is for March's rent, so it has to be applied to that. What happens to February rent? I mean, it doesn't go away. Technically the landlord could get a money judgment for it. They could turn that over to a collection agency at some point. They're just not going to be able to succeed on an eviction case for that. Yeah.
And explain payment by the first and late by the fifth.
Okay, we're getting, it's like requests from it's like a DJ. I like this. I like the interaction. I like the club. No, y'all keep it up. I love this. So the rent being due on the first. So there's a common misconception that tenants think the rent is due by the 5th. And the reason why they think that is there's a statute in North Carolina that it's 42-46 that allows for late fees. But it says late fees can only be charged if the rent is 5 or more days late. And so most leases will say if you pay after the 5th, you owe a late fee. But technically, that's just the late fee. That's separate from when the actual obligation to pay the rent is, which is usually the 1st. And so if a landlord's being really vindictive, like let's say they lose that February case and they're trying to get the tenant the next month, technically if the tenant hasn't paid March's rent by the 1st, the landlord could file a breach of lease on the 2nd, because technically that's when the rent is due. So that's a misconception that we deal with a lot. And that's a good piece of advice if you win on one of these arguments is like, buddy, like next month you got to pay on the 1st on the dot because they're going to be watching you like a hawk, and they might file it as soon as the 2nd if you don't do that. I think we already talked about that's the demand for possession. Justin, that's about the VAWA stuff. This is a fun one too.
All right. VAWA notice requirements outlined in 24 CFR 5.2005. And this is a very common defense that we use in a lot of subsidy cases. And what it says is that for any subsidized tenancy, the landlord must include certain language related to the tenant's rights as a victim of domestic violence. So whether they were a victim of domestic violence or not, the landlord has to do this. The landlord also must include a HUD-approved self-certification form for the tenant to fill out and return if the tenant believes they are a victim of domestic violence. Now, this is, like I said, this is true whether or not there's actual, whether or not the actual termination is domestic violence related. The landlord can't get out of this. And a lot of times they send a notice, but they don't send this VAWA notice. And recently, Tommy just won a case in North Carolina Court of Appeals regarding that.
What's VAWA stand for?
Violence Against Women's Act.
Yeah, and this is a federal law that applies to all subsidized tenancies. So no matter what the subsidy program is, when they give, all of the subsidy programs have, as a general rule, have a termination notice requirement under federal law. And so when they give that notice, they have to include this stuff with it. And if they don't, then we can try to get the case dismissed. Tommy's case, the Drummond case, I think was it this month or last month?
This month.
It just came out this month. We just got this one back. But that was the defense in that case. The tenant had been, was being evicted for breaching the lease. I think for just being a bad neighbor, for like disrupting other neighbors and stuff like that. And it was a subsidized tenancy. The landlord filed the eviction case, did not serve this notice with the termination notice. It was not DV related, but even if it's not, this is still a requirement. It's a requirement for every single termination notice in subsidized housing. That went all the way up to the Court of Appeals, and we got the decision back confirming that. So now, in addition to the statute, we have a case on that now, which is helpful. And this is another thing too, where we didn't push this for years. Like I was, for a while I was doing statewide trainings for legal aid, and I had one of our domestic violence experts come on and talk about where DV and housing law crossover, and she mentioned this, and I was like, what? I was like, I didn't know that applies to like everything that's subsidized. And so we started pushing this too. And that's another thing where we've been getting a lot of success recently on that. And this Court of Appeals decision is the first decision in North Carolina that addresses this issue.
the landlord does sign up the Bono notice and fills out the certification, does that stop the process right then?
It could. So the question is, if the tenant does fill out the form and turns it into the landlord claiming that the eviction is domestic violence related, does that stop the eviction? It could. It depends on what actually happened and whether or not whatever the breach is that the landlord is trying to evict them for is related to domestic violence. Because under VAWA, a landlord's not allowed to discriminate against a tenant based on their status as a domestic violence victim. And so if it's something that's part, that fits that, probably an example would be helpful. So like we have a situation maybe where the tenant's boyfriend comes over, he's drinking, they start talking, it's 3:00 in the morning, he starts yelling, punches her or something, walks out, slams the door, breaks the door, right? The neighbors get really upset. And so the lease says that you can't make loud disturbances like that. And the landlord's trying to evict the tenant for that. The landlord would not be successful if the tenant asserts this defense there because she was a victim of domestic violence in that situation and the breach is directly related to that. So it depends on what the actual underlying issue is.
Because the abuser's not contributing to that portion.
So the question could be non-payment of rent because the abuser is not contributing to the portion of the rent. That is very good. We argued that in one of our briefs because, and that's part of the reason why this requirement is for all evictions in subsidized housing, and the landlord can't like self-select which ones because the landlord doesn't know. Like even something like non-payment of rent could be DV related. Maybe the abuser is not paying their portion, or another example is as a form of control, a lot of abusers will cut off the victims from their bank accounts, or they'll take their debit cards, or they'll steal their ID or something like that, right? So even something that doesn't seem like it's DV related, it could be, and that's why these notices have to be given out in every situation. But only for subsidized tenants. This is only for people that have a rental subsidy. You want to take us off on the implied warranty stuff?
Okay, yeah. Implied warrant of habitability is another defense we use a lot of times where there's outstanding repair issues that the landlord has failed to address. And it can be a claim based on unpaid rent. And it also could be an affirmative claim. A lot of times we bring it defensively in order to get the landlord's case dismissed, but you don't have to. A lot of my clients I have will actually tell me, I don't want to file this now, let's resolve this, and I'll file it on the back end, which, depending on the situation, could be more beneficial for the client.
So these are some of the things that a landlord has to do. The basic premise is, if the tenant requests repairs, the landlord has to make the repair within a reasonable amount of time. We did not have this in North Carolina, I think, until like the 80s. Before that, we were like one of the last states to get this, but we have it now. And these are some of the things that the statute says the landlord has to do. They have to keep the premises in a fit and habitable condition, is the term of art there. They have to obey the local housing code. In Charlotte, we have a very comprehensive housing code. It's really good. I think it's the best in the state as far as tenant protections in there. They have to repair imminently dangerous conditions in a reasonable amount of time. What's considered reasonable could depend on the condition. So if it's like a leaky pipe, maybe like a couple weeks is reasonable. If it's like your heat goes out in the wintertime and it's like 20 degrees outside, maybe like 24 hours is what's reasonable in that situation if it's dangerous, right? They have to keep appliances in good working order. There's not a requirement, for example, that a landlord has to provide a tenant with a refrigerator. But if they do provide them with a refrigerator, they have to keep it in working order. So any appliances that are provided as part of the lease, they have to keep them working. Air conditioning is not in the Charlotte Housing Code. I just said it's really good. That's the one place where it's kind of bad. Like it's not a requirement, but we play around with these types of issues because let's say it's not a code violation not to have air conditioning, but if it's super, super hot, maybe it fits under that other part of the statute that says they have to keep the premises fit and habitable. So even if it's not a specific code violation, if it makes the premises unfit, then that's something we can argue there. Keeping common areas safe, a lot of different things, a lot of protections here. One really important thing is a landlord cannot contract around this. They can't get out of this obligation. So we see this sometimes, even if the lease says in it the tenant is responsible for making all repairs and the landlord, or like the property is being rented as is, the lease can say that and the tenant can even agree to it. That is going to be void as against public policy, and the landlord is still going to have this obligation. So that's something to remember too. There's no way for a landlord to get out of this responsibility.
Yeah, can you speak to advising clients on going to the code enforcement officer to get like a statement?
Yeah, so he's asking about how do they get a housing code inspection done? That's a really good question. It's pretty easy. So they dial 311 and they listen to the menu and they just follow the menu for housing code enforcement. When they request it, the housing code inspector will come out there, usually within a week or so. They'll do an inspection of the property. This is free. It does not cost the tenant anything to do this. They'll do an inspection. If they find housing code violations, they'll make a report outlining all of those. They'll serve a copy on the landlord and they'll give a copy to the tenant. The city will then typically enter an administrative order saying that the landlord has to fix those issues within a certain amount of time. And if the landlord fails to do that, the city can start fining them. I don't remember if it's $100 a day now or like it's $100 a day. So that can be a big incentive for landlords to get stuff done. And sometimes that's easier for us than going the litigation route. We can just tell them, like, if the landlord is responsive, we can just tell them, look, just call the city out and they'll make the landlord do it, right? Now, tenants a lot of times worry about the retaliation in that situation. So you might end up with like a retaliatory eviction situation, but that is a service that's free for tenants. It's also really good for evidence. We will use a self-authenticating affidavit to put the code inspection report into evidence, or sometimes we may call the code inspector as a witness to testify. But that's an impartial third party that can verify that these conditions existed and these problems were there. And the court is going to give a lot of deference to that code inspection report. So it's also just good for building your case if you think you're going to file a claim.
As a follow-up to that, in terms of, like, let's say you have a situation where you're facing an eviction for non-payment. You didn't pay. And they're saying, hey, I didn't pay this, my heat doesn't work. Is that an opportunity from a legal strategy standpoint to say, let's get a continuance? Or what would your strategic approach? I dealt with that.
Yeah, so the question is, if you have a situation where you've got a tenant that's behind on the rent and they're not paying their rent because they withheld it because they're frustrated because the landlord's not making repairs, like what's a strategy you can use there? I have asked for continuances before to try to get the code inspector out there before the next trial date, and sometimes that works. As a general principle, I will advise tenants not to withhold rent. There is a law in North Carolina that says that tenants are not supposed to unilaterally withhold rent. They're supposed to get a court order saying that the rent's more than it should be. As a practical matter, what's going to happen if they withhold rent is the landlord's going to file an eviction case, and then it's going to be up to the judge. If they have significant counterclaims, and we file counterclaims for this, and we can show the judge that the amount that the landlord owes them is more than they owe the landlord, most of the times the judge will dismiss it in that situation. Dismiss the landlord's case, but the judge has discretion. They could award damages to our client, but then evict the tenant anyway. So they have a little bit of discretion there. So I always advise tenants, it's better to keep paying it and then try to get it back than to not pay it, and then you're putting yourself at risk in that situation.
Yeah, there's no requirement to put in escrow at the in-between stage.
Yeah, so the question is there a requirement to put in escrow in the in-between stage? There's not a mechanism like that in state law. If the tenant has lost in small claims court, and the case is going up on appeal, then the tenant's going to have to start paying their rent bond into the court. That money is going to stay in escrow until the judge on the appeal decides what to do with it. So that may be a situation where the judge, if the tenant's got really good claims, the judge may decide that bond money should be returned to the tenant instead of going to the landlord. But outside of that appeal process, there's not a mechanism for that. Yes.
Just quickly, going back to the warranty of habitability, there's no requirement in the housing code to have air conditioning. But if the unit does have air conditioning, has some air conditioning installed that's not working, does that create an argument that the landlord has a duty to repair that?
That's a really good point, and I think that's great. So Mark's mentioning that there's no requirement in the housing code to have air conditioning, but if the landlord supplies an air conditioner and it breaks, is there an argument that the landlord has an obligation to fix it? The answer is yes, because part of chapter 42, part of it says you have to obey the local housing code. So we're not going to be lucky with that. But another part of 42-42 says that the landlord has to repair any appliances that it supplies. And so if they have supplied one and it breaks, although they may not be violating the housing code, they're violating that statute in that situation. But if they never provide one at all to begin with, that's a different situation. And that could be a problem.
As they talk about how that doesn't mean you get to pay zero, like it's some subjective number.
Yeah. So, and the way that we, I don't know if we have a slide on that. The way that we calculate, the way we calculate damages on this, it's a contract claim at the heart of it. So it's a claim based on the warranty that the place is going to be in good condition. So the tenant is allowed to give their opinion about how much they think the property would have been worth per month, what a fair rate of rent would be if everything was fixed, if everything was up to code, right? And usually they're just going to go with whatever amount they agreed to pay, the contract rent. Then the tenant's allowed to give their opinion on what they think the property was actually worth during that time. And then if the judge grants the claim, they're going to take the difference of that and give it back to the tenant as damages. So if it was $1,000 in good condition, but it was only worth $500 in this actual condition, the court could give the tenant back $500 for every month that the tenant paid rent. The tenant has to be paying rent during that time to get it back, right? But that's how they calculate the damages. They also will allow for consequential damages or like out-of-pocket expenses. So let's say that the heater breaks and the tenant has to buy a bunch of space heaters, they can get the money for that back. Like anything they have to pay out of pocket. Another thing that's really common is like leaky excess utility bills. So let's say the pipes are leaking and their water bill goes up by $50 a month and they can show that. They could ask for that excess utility back as well. So that's how those damages are calculated. And Todd tried one of those in small claims court. So we had a case where he filed a counterclaim for his client on this and was successful in small claims court and got a judgment there for several $1,000s. We're going to skip ahead. This is talking about how to prove it. Code inspection reports are always good. Let's get into the unfair. Let's start, Justin, you want to talk about just the unfair and deceptive action practices claim, the Article 1 claim? Well, just in general about what that is.
But the unfair deceptive?
Yeah.
When I do the claim, I think you should probably.
Are we that close?
Yeah.
Oh, yeah, we might need to rush through this. Okay, well, we're running short on time. These are consumer protection laws that we also use, and there's two of them. We're going to go through these briefly because they're a lot of fun and they're very helpful for our clients. Unfair and deceptive action practices. This is Article 1 of Chapter 75. Says it's illegal for a landlord to use unfair methods in commerce, basically. Anybody that's an attorney for a bank will probably know all about this because it's an issue you look at a lot. But with this, what it allows for is where we have cases where the repairs are not being made, we have really good case law that says that the landlord collecting rent while refusing to make repairs is an unfair practice. It's an unfair act as defined by this consumer protection statute. And so we will always file those claims together. So we file the breach of implied warranty for the repair issues along with the unfair and deceptive claim. The reason we do that is because this claim allows for treble or triple the amount of damages. So that $500 a month you're going to get back for your client, if both claims are granted, it becomes $1,500 a month. And you also can ask for attorney's fees. So if you try to make a reasonable settlement offer to the other side and they refuse it, you can get your attorney's fees back as well. And so that's why this really packs a punch, because if you get it, you're getting 3 times the amount of damages you'd otherwise get. And then with that too, illegal the debt collection claims. So that's Article 1. Article 2 of Chapter 75 deals with unfair debt collection practices, and there's a few different ones there, but the one that we'll talk about is fees that the landlord's not legally entitled to. So part of that statute says a landlord who's considered a debt collector under our case law If they collect or attempt to collect a fee that they're not legally entitled to, that's a debt collection violation. And the remedy there is also pretty cool because it's anywhere from $500 to $4,000 as a civil penalty for each time that the landlord violates that statute. So the way that we use that, we'll argue, for example, let's say there's an illegal late fee provision. Like maybe the late fee says they can get it if it's more than 3 days late instead of more than 5, which is what the statute required. For every single time the landlord tried to collect one of those illegal late fees, we'll pop them for one of these penalties. And it can be substantial sometimes, because if it's for 10 months that they did that's a minimum of, we'll argue that's 10 violations. So that the minimum amount of recovery there it would be like $5,000, $500 per each time the landlord tried to do it. And so that can give us a lot of leverage too. We bring these claims very often. The magistrates are pretty receptive to them, and it's kind of a good leveling tool where you can use this as a claim to kind of offset rent that's owed. And so we're successful with that pretty frequently as well. The other thing, we're going to have to wrap this up soon, but the other thing I wanted to mention as far as the housing code, the reason I like Charlotte's housing code so much, despite the air conditioning thing, is because it has this provision that says for certain conditions, if they're on the property, the landlord is not allowed to collect any rent. And these, we call them the dirty dozen. I think it's actually 13 of them. But these are things like rat infestation, only rats, not mice or squirrels. We had a squirrel one time. We're like, the squirrel, is that close enough to a rat? This is rat infestation. So that's considered imminently dangerous. No heat during the winter time, no potable water. You can see unsafe electrical wiring. We do have clients whose apartments catch on fire sometimes because the wiring is so bad. So if one of these conditions exists on the property, the landlord's not allowed under the city code to collect any rent at all. And if they have one of these conditions on there and they try to collect rent, then we'll bring both the unfair and deceptive and the breach of implied warranty claims. We'll also bring a debt collection claim because we'll say that they're not legally entitled to collect any rent while this condition exists. And if they try to do that, they're trying to collect something they're not legally entitled to. And therefore, we'll also ask for the debt collection penalty on top of that. We just went through this stuff. Some of the stuff, improper late fees are common. Just the landlord trying to get the tenant to agree to pay something or the landlord trying to charge the tenant for something the tenant never agreed to. That could be one. So these are just some examples of different types of fees that could be illegal. And we just talked about this too, Article 1 versus Article 2. We're gonna go through appeals and then we're gonna take questions. I think we started a little bit late, so I want to make sure everybody gets their CLE credit. So we'll try to wrap this up within the next 10 minutes. If you lose, you can file an appeal to the district court within 10 days of the judgment. So this is kind of like the saving grace of these eviction trials. The first trial happens super fast, but you have, as a matter of right, the tenant can appeal that judgment if they lose, even if the tenant doesn't show up for court. So even if it's just basically like a default judgment, they can still appeal it. They can stay in the property while they're waiting on their appeal trial, but like we said, they have to start paying their rent into the court as a bond payment. They don't have to post the back rent as a bond if they qualify for legal aid services. So if they qualify as indigent, they can get the filing fee waived for the appeal, and they can also get the requirement that they pay the back rent as a bond waived, but they still have to pay the rent as it comes due into the court. And if they fail to do that, or if they're late on one of those bond payments, the landlord can evict them even before their trial comes around. You can only file an appeal where you're an aggrieved party. So why does that matter? We had a case where we filed counterclaims. The maximum jurisdictional limit in small claims court at that time in Mecklenburg County was $5,000. Now it's $10,000. We got everything we asked for from the small claims magistrate. We got the $5,000 judgment. We got the landlord's case dismissed. And then the tenant's like, can we get more if we appeal it? And we're like, sure. So we appeal it. So on appeal, we got more than that. I think it was, no, we got less actually. That was the funny part. We got less on the appeal. It was like $3,500. But the judge also denied our unfair deceptive claim and didn't treble it. So we filed an appeal based on saying the unfair deceptive claim should have been granted. The other side was scared of getting that treble damages against them if they lost. So they made this argument that our client was not an aggrieved party because she got everything that the court could possibly give her in small claims court, and the Court of Appeals agreed with that. So that's why we mentioned that, which was funny because then the court reinstated the $5,000 judgment, which was more than the district court judgment. So we're like, was that a loss? I don't know. I'm not sure. But we mentioned that because be aware of that. If you have a really, really strong counterclaim, if you file it in small claims court, you don't have to. You can wait until the appeal. But if you file it in small claims court and you hit that $10,000 jurisdictional limit, if the other side doesn't want to appeal, then your client's stuck with that, right? They can't then appeal and then try to get more in district court. So that's why we mentioned that. There is time for discovery on appeal. You have to get it out quickly because the appeal trial is usually only like 2 or 3 months out. But there is time for that. There's no time for that in small claims court. So that's why small claims court is fun, because you're walking in there like only knowing what you know from your client and what you've been able to get on your own, but you can't do any discovery before the small claims day. District court's usually 3 to 4 months. They've been doing the counter call remotely on WebEx. They've changed that now. They're going back to in-person counter calls, but the actual trials are actually on WebEx. So they're remote trials, which is weird. I don't like it. But for the district court appeals, the trials are on WebEx. For small claims court, everything's in person.
You can ask for it.
You can ask for it in person. If you don't want to do it on WebEx, there's a form you can request, but it's completely discretionary for the judge if they'll allow that or not. And then once the judgment's final, whether it's on appeal or wherever, the landlord can get the writ of possession, which is the document that tells the sheriff to go assist with the lock change. They can't, you've got the 10 days after small claims court to file your appeal. So they can't get the writ during that 10-day period. If you go to district court and have a trial and you lose, there's a 30-day appeal period from the date of that judgment where the tenant could technically file an appeal to the Court of Appeals. And so during that 30-day window, as long as the tenant keeps their bond current, the landlord has to wait the 30 days before they get the writ. But once the writ's executed, once the sheriff goes out, and what happens, the sheriff goes out, they tell them like, you've got like 5 minutes to get out, right? They take the tenant out, and then they'll just basically stand there and act as like a peacekeeper while the landlord, changes the locks, or the maintenance guy comes over and changes the locks. But the tenant's property is typically left in the property. And so what the law says about that is after the locks are changed, the tenant has the right to get back into the property. The landlord has to provide access to the property so they can get their belongings out. They've got 7 days to do that. After the 7 days expires, the landlord can dispose of that property or do whatever they want to with it at that point. So that's an important piece of advice. If you have a client that loses or they miss their bond payment and that they know that writ's coming, making sure they understand that they've only got a week to get their property out is really important advice.
So as they talk about, like, if they lose in small claims court and they can't appeal, how quick they're actually going to be locked out, because the magistrates will tell them you got 10 days to move out, but really they got longer.
Yeah, so the question is, if you lose and your client does not want to appeal or can't appeal for some reason, maybe they're not going to file the appeal because they know they can't make the bond payment or something. After the 10-day appeal period is up, the landlord can go on the 11th day and file the writ, and that's what's going to start the actual eviction. Typically, it happens within like a week to 2 weeks after that. So the 10 days expire, landlord files the writ. The sheriff's supposed to go out to the property once to give a notice of when they're coming back. So they'll be like, here's your notice, we're coming back next Friday. This is your notice, we're going to change the locks at that time. And then they'll come back on that date, which is, again, typically within like a week or so to change the lock. So it's really more like 20 days or something like that rather than just 10 before the actual eviction takes place. Deposits we don't really deal with that often. Landlord's got to give an accounting within 30 days, an itemized list of any deductions. There's some funny provisions. There's a case that talks about if the landlord fails to tell the tenant in writing where the deposit is being held, that means that the landlord might have to forfeit the entire deposit back to the tenant. We don't deal with these issues a ton, but a lot of times clients have questions about them. They get really hung up on the security deposit. It doesn't matter what else is going on. They're like, I want my deposit back. It could be like any number of other things, but they're really, really vocal about that a lot of times. Does anybody have I think we're close to time. Does anybody have any other questions? Yeah.
Will you make these slides available?
Yes, I think, Angie's got them and I think can send them out. And that's fine to do. Thank you. For people online, your second code word is service. So for your CLE credit, the second word is service. Any other questions for right now?
Would you just say a word about what people can expect if they sign up for one of the clinics?
Yeah, that's great. Yeah, that's important. So for the clinics themselves, what you can expect is that you'll get a notice of when we're going to do it. It's going to be at 9 o'clock in the morning on some day, Monday through Friday. If you sign up, then we'll be expecting you. You'll show up to court at the courthouse, come up to the second floor, which is where small claims court is, and legal aid will be waiting there to meet with you. So we'll talk with you, check in with you and everything. You'll sit in and watch the calendar call, and then when the magistrate announces that legal aid is there, you'll follow us out into the hallway, and the tenants that want to talk to us will come out. And then what you'll help us do is a couple of things. First, we have like a questionnaire to determine if they're eligible for legal aid. It doesn't take long, so you'll walk them through that. If they don't qualify, you'll inform them of that, and we have like an information packet you can give them. If they do qualify, you'll say, great. If you've done it before and you're comfortable doing it by yourself, you can, or you can grab one of us to do it with you, and we'll talk to the client and try to identify any defenses that they may have. And then we will either give them advice or we will sometimes agree to represent them on the spot. The whole process takes maybe like 2.5 hours or so. We only expect you to come for that day. So like I said, you don't have to keep the case afterwards if you don't want to, although some people like Todd decide to do that, which we appreciate. So if you want to stay with it, that's fine, but that's not the expectation. And then at the end of everything, you'll just turn all of your information back over to legal aid, and we'll get everything plugged into our system and recorded and everything. Yeah.
So when you're talking through possible defenses, is there like a script or like a list of questions that you kind of go through?
Yeah, so the question is, when you're trying to issue spot for the tenant, is there a tool to help you do that? We do have a questionnaire that walks through the basic defenses. We have other resources, like we have a cheat sheet that has all the elements of the eviction claims on there. Typically, it's a lot of times, like, did they make a demand for possession? Because that's like the most common thing they forget to do. It's like, do you have a ledger with you? And if we see any like suspicious fees on there, that might be one. And then we'll ask them, like, are there any like repair issues going on? That's like the common stuff, because we don't have a ton of time, and those are like the three most common things that we use. So we usually start there, and then if none of that works, we might dig into the questionnaire and try to find some other stuff to try to use there. There are other opportunities to volunteer besides the clinic, and I want to make sure that that's clear too. You don't have to do the clinic if you want to volunteer and take a housing case. You can also just take a case directly from us. Maybe you don't want to do the in-person thing at the clinic. Maybe you want more time to study and look at it before you have to go to court, right? So in that case, maybe you can take one of our appeal cases for us, right? And then you've got maybe 2 or 3 months to dig into it, to investigate. You can do discovery if you want to, and you can prepare for the appeal trial. So that's another opportunity where you can just take a case directly from us, not through the clinic, but we'll just assign it to you, and then we'll send you a letter with all the information, and you call the client. In all those situations, we're here as subject matter experts. We're happy to talk with you about that. Any questions that come up, we have sample pleadings, we have sample counterclaims, all that kind of stuff too. So there is a support network there for you in either one of those situations. And then the third opportunity, for people that are not comfortable with litigation, we do have lawyer on the line opportunities, which is essentially a program where we have pre-screened clients that have issues. We'll come to you, like to your office or wherever you want to do it. We'll sit down with you, give you a packet explaining what the issue is. You'll research it. You'll talk to Justin or myself or another subject matter expert that's on site. And the goal there is advice-only cases. So the goal is to research, look at it, call the tenant, give them some legal advice that's helpful, and then we put that in a letter and we send it to them. That doesn't involve any kind of court at all, but that's something that is that's also available. I will say, for people that haven't done litigation and you might be interested on whether you'd like it or not, and you want an opportunity to like try it out, this is the best place to do that. And the reason why is because of that de novo appeal. It takes a lot of the pressure off, because like even if something just goes completely sideways and you lose the case, you can still file an appeal and you get a do-over, right? So that's something too. And I'll tell you as well, if you don't have a lot of experience litigating, we're happy to co-counsel that stuff with you. Or if you just want to co-counsel with us, because you want a buddy that's a long-term attorney or whatever, we'll do that too. And Todd and I just got done with one last week that we worked on together for a while. I had a lot of fun with that one.
I think, how many people do they have to have while you're on the line?
I'm not sure about that.
I mean, you're not going one-on-one.
Yeah, I'm not sure. Usually it's like usually when we go, it's between I would say 7 to a dozen people. You think that's right, Justin?
Yeah.
Yeah.
Our plan is to have one available at least once a month in 2024 that anyone, there'll be at different places.
Different places,
around, but you can go if you're part of the program.
Yeah, we've been doing that. We've been going to offices and doing that. The Honeywell is a big fan of that. They've had us over there 3 or 4 times. I think that's the longest one we've been doing. But for people that are interested, yeah, we'll come to you. And like Todd said, there's going to be a rotating schedule of them that's going to. So if your firm or your company or whoever you work for is not doing that right now, and you think they may be interested, you can talk to Todd or Andy or whoever, and we can get some more information on that.
Just one last thing on the clinics. We've got clinic tomorrow.
Yes.
We've got one on Friday as well.
Oh,
A lot of volunteers for tomorrow, but I think we were looking for some more folks for Friday.
yeah. Justin, can you tell them what the plan is? So what's the plan for?
I was actually getting ready to mention that. So anybody that hasn't wants to attend a clinic just to kind of see what's going on, see what it looks like. We have one scheduled for tomorrow and Friday at 9 o'clock. As of right now, we have a good amount of volunteers for tomorrow, but we don't have a nice amount for Friday. But with that being said, I do not have the dockets for Thursday and Friday. So I'm not sure if it's going to, if we're going to have a lot of cases. So if you want to come and you've never been, please come check it out just to kind of see what it is. Even if we don't have a lot of cases, it's a good experience to kind of see what's going on. And for the ones that have already said that they're coming tomorrow and Friday, tomorrow I plan to get to court fairly early, so I would check the dockets. And if the dockets are slim, I would send out a mass email to everyone on the email chain letting you know that the dockets are small. So if you want to come, you can. If you don't, I understand.
But if you're not comfortable jumping right in and giving advice, even if you just want to come, just watch, you don't have to participate the first time. If you just want to come check it out, that's fine too. And even if there's not a lot of stuff going on, like Justin said, it might be helpful just to sit and watch what happens. Even if it's a small docket, just to sit and watch some of these cases be tried in front of a magistrate will give you a really good, taste of what's going on in there.
And I will say this, I have a trial tomorrow that is definitely happening tomorrow. We have a potential res judicata argument and definitely a vowel argument that we will be making.
Yeah, and Justin always wins, so that'll be fun.
Can you just let the time for folks, whatever hours for the call?
Oh, it starts at 9, and generally it's about 2 hours from about 9 to 11, 9 to 12, kind of depends on the docket size. Every once in a while, I may stay, or we have some volunteers that stay past 11 because we have a good sized docket for 11 and 12, but generally it's just 2 hours. And we understand, this is volunteer work. You guys have other stuff you need to do. So just coming out, even if it's for an hour, is very helpful.
All right, thank you all so much.
Thank you.
Thanks so much to Isaac and Justin. That was terrific. Tons of information. If anybody has questions or if you're interested in the clinic on Friday or any of the future clinics, reach out to us and let us know and we'll get you plugged in the right place. There are literally hundreds, probably thousands of Charlotteans who have a roof over their head tonight because of the work that these guys at Legal Aid do and because of the work that is done by pro bono lawyers around the county and has been for a long time. So this is important work. We really appreciate all the work that you do for our community, and we look forward to finding new ways to support you and get involved in it as well. Thanks to everyone again for coming.
You want to repeat the code?
Yeah, I will repeat the codes one time for the folks on the line. It was Triage was the first code, Service was the second code, Triage, and then Service. For those in the room, I think most of you probably signed one of the forms over there that has your CLE information. If you have not, please do so. They're identical, so you just need to do one or the other of them. But just be sure you've signed that and put in your bar number so that we can be sure you get CLE credit. Thanks to everyone. Great to see all of you here. Great to see so many people on the line, and I look forward to seeing those of you who can make it over to the Grand Bohemian for the reception in a few minutes. Thanks.